Okay, everyone, this is my second video about recently unsealed search warrant applications in Don Lemon's criminal case. Now, the warrant applications were rejected, not granted. In the first video, I discussed the fact that one of the magistrate judges, John Dougherty, had falsely accused the government of seeking subscriber information for Don Lemon's YouTube channel. The government did no such thing. The word subscriber does not even appear in warrant application number 205. The government wouldn't need that type of information to connect Don Lemon to any crime for which he's been indicted. Now, let's recall he was indicted in January for storming a church in Minneapolis with a group of anti-ICE protesters, shutting down the worship service, chasing the churchgoers out, even terrorizing children in the church. Now, it was a horrible display of anarchy and attempted intimidation. Now, I had mentioned in the first video that I would follow up after getting hold of the rest of the unsealed warrant applications, which I did. And guess what? The government did not seek subscriber information for the YouTube channels of any co-conspirator in Don Lemon's criminal case except for one, Georgia Ford's, and it was obviously a drafting error in the warrant application. Defendant Georgia Ford says she's just a journalist who was reporting on the church attack and not an active participant in the attack. Same defense as Don Lemon. Now, the word subscriber does appear in the warrant application for Georgia Ford's YouTube channel. However, the context indicates it was a mistake by the DHS special agent who drafted the application. Now, that doesn't excuse the mistake, of course not, but it's apparent from the context that it was a drafting error. Now, apparently, the DHS special agent filed the search warrant applications without the concurrence of the U.S. Attorney's Office. DOJ regulations require a U.S. Attorney concurrence for search warrant applications except in rare and emergent circumstances. So, technically, the DHS special agent could have gone forward without the concurrence, which is what he did, but the U.S. Attorney's Office in Don Lemon's case is comprised of government attorneys from the DOJ's Civil Rights Division. Over the past few months, the derogatory comments in the media about the DOJ's prosecution team for Lemon's case have proven to be unjustified. Now, I realize DHS special agents are used to a different type of procedure for administrative warrants, but here he was seeking a judicial warrant, and that's a lot more complicated. The behavior of the magistrate judge, for example, is another reason why a U.S. attorney concurrence would have been well advised, because the magistrate judge, in my view, flipped out. Okay, he misread the warrant applications. He took what appears to be a Scrivener's error in one warrant application, the one for Georgia Ford's YouTube channel, and he blew it up into an inflammatory false accusation against the government for allegedly seeking subscriber information for Don Lemon's YouTube channel, which is not the case. That's just false. Now, back to the drafting error. Judges are busy. They receive a warrant application. Often the judge hasn't read the application or hasn't read it carefully, and all of a sudden the judge is making decisions based on his own preconceived notions that he brings to a case. Now, judges make mistakes. Everybody does. And here, it doesn't help that the warrant applications were filed as a group, 5 of them. And 2 of the applications were only seeking Apple iCloud information for 2 of the co-defendants, Nikema Levy Armstrong and Ian Davis Austin. Now, Apple iCloud uses the term subscriber to refer to the owner of an Apple iCloud account. So the word subscriber is used differently by iCloud compared to YouTube, which only added to the problems in drafting the warrant applications. Now, apparently defendant Austin, at the time of his arrest, tossed his iPhone and said, "Don't let them get hold of my information," or something like that. Now, just to repeat, the government did not seek YouTube channel information at all for defendants Ian Austin or Nikema Levy Armstrong. Now, warrant application 207 sought YouTube channel information for defendant William Kelly, aka DeWoke Farmer, but not information about his YouTube subscribers. The word subscriber does not appear at all in warrant application 207 for defendant Kelly, or for the warrant application regarding Don Lemon's YouTube channel. And that's important because if the warrant applications had been granted, they would have been served, the warrants would have been served on YouTube, the corporation. Now, YouTube is a subsidiary or division of Google, and YouTube, if I had to guess, in all probability would not have complied with the warrant to the extent of subscriber information and might even have filed a motion to quash the entire warrant or filed a motion for clarification. Now, it's extremely burdensome for corporations to produce a large amount of data, first of all. A motion to quash can be filed just on that basis, that it's too burdensome to produce all of that data, and would you be more specific as to what you're seeking? But the warrant applications were denied. Now, that was in February. More recently, during the process of unsealing the applications, the U.S. attorney was asked to weigh in, and the U.S. attorney said, "We don't object to unsealing them. Just redact the personally identifiable information." And the U.S. attorney stated that the warrant applications could have been more narrowly tailored. So, if the applications had been granted, YouTube probably would have just worked out the parameters of the production with the U.S. Attorney's Office rather than filing a motion to quash. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.